Hey everyone, thanks for joining us today. My name is Daniel Burroughs. I'm one of the managing attorneys at Burroughs Elijah Law Firm. So today we will be talking about estate planning and elder law. So this is a very comprehensive seminar. I often call it Estate Planning 101 and Estate Planning 102. And we're really covering enough information that you could probably spend 2 semesters in law school really going over the fine details. So one of our goals today is for you to understand the issues that may affect your particular situation as far as your estate plan goes. So a lot of people have the misconception that estate planning is only for the super wealthy. And I would disagree. I would say most of our clients are middle class or upper middle class people. They've worked hard, they've saved up some money, they've paid off their house, and they want to make sure that they have certainty about where their property goes upon their death. So in order to understand exactly how property will be divided upon death, it's important to understand exactly what the client owns. So we have to take into account personal property items, right? Many times, if there is a dispute among family members, it's those sentimental personal property items, but also different accounts, bank accounts, IRAs, life insurance policies. It's also important to understand whether or not those accounts have a beneficiary upon death, because that will really determine who the property goes to, even if a will says something else. So for example, I met with a client and we were reviewing her life insurance beneficiaries, and she actually had her ex-spouse listed. And I haven't met any clients who actually want their ex-spouse to get a check for $500,000 when they die. And that would have been a grievous error, because it would have paid out. There wouldn't have been a way to challenge that because the beneficiary designation controlled. So the details are very important when organizing an estate plan. If someone simply thinks that signing a will is sufficient without understanding the assets that they have and how they pass upon death, there's a risk that their estate plan is not going to do what they expect it to. So, in addition to planning for distribution of assets upon death, it's important to plan for incapacity. So there are some documents, including a durable property power of attorney and a healthcare power of attorney, that name an agent who can manage your finances and property if you become incapacitated, or to make medical decisions on your behalf. And typically the healthcare power of attorney is paired with something called a living will. And the living will is important because it communicates your preferences for end-of-life care, whether that involves a ventilator or nutrition or hydration by tube, things like that. Specifically, if you have a terminal condition that will result in death in a short period of time, or a permanent vegetative state. Additionally, a last will and testament is an essential document that should be a part of any estate plan. So regardless of how wealthy someone is, or even if they don't have a lot of money, it's important to have these 3 documents: the last will and testament, the durable power of attorney, and the healthcare directive. There are a number of different estate planning tools that we have, and some of them are better than others, but it really depends on the circumstances. So for a lot of individuals, a last will and testament is a great estate planning tool, and it's important because it allows us to draft around state law. If someone dies without a will, state law determines who their property goes to. To provide an example, consider a married couple, husband and wife, and they have 3 adult children. If the wife passes away without a will, her husband in South Carolina is only entitled to 50% of the estate. In Georgia, he's only entitled to 1/3 of the estate. So I don't know a lot of married couples who actually would want that to be their plan. So by having a last will and testament, they will have the certainty that all of their property can pass to the surviving spouse. Now, in a situation where, the children are joint and they're in agreement, it's not necessarily a big deal because they could waive their interest. But what if we have a blended family? Or what if we have a child with addiction issues or creditor problems? Even if they want to sign over their interest, their creditors may not let them. So last will and testament, very important. What if we have an individual or a beneficiary with special needs? And because of that, they may need government benefits that pay for health care, pay for housing and things like that. Well, we don't want them to get an inheritance that would cause them to lose those benefits. But if we plan ahead, we can leave their inheritance in a special type of trust called a special needs trust. And the trustee of that trust could use the money to pay for things that the beneficiary needs that supplement those benefits without causing them to lose them. So special needs planning, very important to plan ahead. We actually have a separate seminar that covers just special needs planning because it is a very detailed and nuanced area of the law. Additionally, a revocable trust is a great estate planning tool, and it really does everything that a will does, but there are some advantages. By using a revocable trust, we can avoid the probate process, which in South Carolina can take up to a year, or even longer if there's other complications. So we'll talk about why avoiding probate may be appropriate or not. And finally, we have an irrevocable trust. And we'll talk about the differences between the revocable and the irrevocable trust. But the main purpose of setting up the irrevocable trust is to avoid a situation where a client's entire life savings is depleted because they're paying for nursing home care or some other form of long-term care. Once a client runs out of money, their options become very limited. So our goal is to make sure a client does not outlive their money. So focusing on a last will and testament, this is the foundational estate planning document, and it's really a list of instructions. It identifies beneficiaries. So oftentimes you will see a provision that says all of my assets pass to my spouse upon my death. And if my spouse is not living, it goes to my children in equal shares. So we can identify a primary and a contingent beneficiary. We may want to put specific provisions in the will that say, if a beneficiary is under age 30, their share is going to be retained in trust until they reach that age. That way, we protect a young beneficiary from squandering their inheritance. Or maybe we want to disinherit a child. We can include a specific provision that intentionally disinherits them so that they can't argue they were left out by mistake. And then we identify our executor, or in South Carolina, it's called a personal representative. And that's the person who's in charge of executing the instructions that you have written in your will. And importantly, the will is only effective upon death. So the executor has no authority to act during lifetime. When drafting a will, it's important to understand that it will only control what happens to probate property. So we really have to know which property will pass through probate upon death and which property will pass outside of probate. So if you look in the right-hand column, pretty much any financial account can have a designated beneficiary. So if you designate a beneficiary on any financial account, then it will not go through probate. Therefore, the will does not control who that property goes to. Maybe someone has joint bank accounts. Well, those are considered joint with right of survivorship, which means if one owner dies, the other owner has the right to take all of that money. So many times with married couples, it makes sense to have joint bank accounts, but I've seen where parents have added children as joint owners on large accounts, and that can cause problems because, maybe their intention was for all of the money to be divided equally among the children, but if one child is a joint owner on a large account, they're under no legal obligation to share that money with the other kids. So we have to be careful when adding children as joint owners. And then assets inside of a trust will also avoid probate, and we'll cover that topic in more detail in a couple slides. So the probate assets in the left column would include single owner real estate, or maybe jointly owned real estate if it is not joint with right of survivorship. So it's important, particularly again for married couples, if they do get a deed to property, to make sure that it specifies joint with right of survivorship and not just a joint interest where they each own half. That could be the difference between a surviving spouse going through the probate process or not. Stocks or bonds that are not inside some sort of brokerage account would go to probate, single owner bank accounts that don't have a beneficiary, and then personal property. So when a person passes away, whoever is in possession of the will is under a legal obligation to file it with the probate court. We have to notify all of the family members. So this would include heirs at law and defined by statute. So let's look again at the married couple with 3 adult children. If the wife passes away, her heirs at law would include her husband and all 3 children. And that would be true even if her will disinherited the children. They still have to be notified of the probate process, and they would have an opportunity to object to the probate of the will, which could cause problems. Assuming no one objects, and assuming the will is valid, the judge will appoint the executor. And that is when the court will issue official documents, which in Georgia are called letters testamentary. In South Carolina, they're called fiduciary letters, along with a certificate of appointment. Once the executor has those documents in hand, they then have authority to take control of estate assets. They need to create an inventory, figure out everything that the decedent owned, pay any debts and taxes. We have to run a publication in the newspaper for a number of weeks to notify any potential creditors of the estate and give them an opportunity to make a claim. After the publication occurs, in South Carolina, there is a mandatory 8-month waiting period where creditors have an opportunity to make a claim. In Georgia, it's a shorter period of time where they have 12 weeks to make a claim and establish priority before the executor can distribute assets from the estate. And finally, after any debts or taxes are paid, the assets are divided among beneficiaries under the terms of the will. As far as estate tax goes, a lot of individuals are worried about death tax or estate tax. Georgia and South Carolina currently do not have estate tax on the state level. However, there is a federal estate tax, and the limit right now is $10 million indexed to inflation. So an individual in 2020 can pass away and own over $11.5 million, and their estate will not be taxed for that amount of money. So if someone does owe estate tax, it's a good problem to have, but most people just don't have to worry about it. There are some probate challenges that may come up depending on the decedent circumstances. The number one issue is family drama. So if we have a blended family, second marriage, or maybe a child with addiction issues or someone who just doesn't get along, that can cause serious problems in probate. It's also important to understand that a will only controls probate property. So there are situations where someone has 2 different estate plans and they don't really realize it because their beneficiary designations are not consistent with the terms of their will. We already addressed the delays. So in South Carolina, probate can take up to a year. In Georgia, it can take about 6 months. Or what if someone has property in more than one state? So maybe they live in South Carolina, but they have a beach house in North Carolina. Well, now we have to do 2 probates. And the laws for foreign probate, or what we call ancillary probate, differ based on whatever county the property is located in. So that can mean delays, more red tape, more expense. If the client owns a business, that can create complications if it goes into probate, particularly with the management of the business and the taxation of the income. And then if we have beneficiaries who are minors or who have special needs, the court will have to appoint a guardian ad litem to represent that individual. So once again, more delays, more red tape. Typically, the guardian ad litem is an attorney, which is going to be more expense. Before we talk about avoiding probate and avoiding those issues, we have an example here of someone who has two different estate plans without really realizing it. So Sarah, unfortunately, passed away unexpectedly, and she's survived by two children who are no longer minors. They're age 19 and age 21. So they're very young and inexperienced, but they are considered adults. Sarah did draft a will when they were younger, and the attorney put a provision in there that said if any children are under age 35, Sarah's sister would manage the money as trustee to protect a young beneficiary from squandering their inheritance. So Sarah's house becomes part of her probate estate, and the executor will be able to sell the house and divide the proceeds among the trust shares. Unfortunately, when Sarah took out her life insurance policy, she named her children as the beneficiaries. So now a 19 and a 21-year-old are each going to get a check for $50,000. The question is, do you think they're going to put that money in savings, use it to start a business? And the answer is no. They're almost certainly going to buy a car worth $50,000 or put a down payment on a car worth more than that. With proper planning, Sarah could have protected that life insurance money in the testamentary trust as well. However, since she didn't understand the details or how the law worked, she unfortunately has two different estate plans. So moving on to a revocable trust, once again, the main purpose of this trust is to avoid probate. So the trust does a few things. It names a trustee. So the trustee is the person who is in charge of managing all of the trust property. So I like to think of a trust like a box that you create. So as soon as you sign the trust document, you have established the four corners of the box, and you can put property in there. So you could deed your house to a trust. You could put a bank account into a trust or open a trust bank account. You could retitle stocks to a trust or even name the trust as beneficiary on your life insurance policies. And whatever you put into the trust is under the exclusive control of the trustee. No one else can touch trust property without the trustee's permission. So typically, when clients set up a revocable trust, they will name themselves as the trustee, so they still control everything inside the trust box. And the clients will also be the lifetime beneficiaries, meaning they can use trust property for their own benefit with no restrictions. However, the trust also specifies that upon the death of the client, or in the case of a married couple, upon the death of the surviving spouse, the trust becomes irrevocable and will divide property among the death time beneficiaries. So maybe that's children, maybe that's grandchildren, or maybe it's a charitable entity. It can be whomever we want, but it does have to be in writing. So the main reason to use a revocable trust is to avoid probate. And we kind of covered some of the issues that come up, the delays, the expense, the risk of family drama, which may be caused by what I refer to as complicated family dynamics. I will mention that a trust is more expensive to set up on the front end, but it tends to save money on the back end by avoiding the attorney's fees that are often associated with administration of an estate upon death. So when we talk about family dynamics, just to touch on some red flags that we look for as estate planning attorneys, if children have addiction issues or troubled marriages, or maybe we have minor beneficiaries or special needs beneficiaries, that can lead to complications where a court-appointed attorney has to get involved during probate, which means more delays, red tape, expense. Maybe a child just has money management issues. That's a great reason to use a trust, because you don't want their creditor problems creating issues during the probate process. So a quick recap of a last will and testament versus a revocable trust. These are both good estate planning tools, but just like you're not going to use a hammer to put a screw in the wall, you need to use the proper estate planning document to address your specific needs. So a will is only effective upon death, meaning that the executor has no authority to act during the client's lifetime. Whereas a revocable trust is effective immediately when it's signed. This is often called a living trust or an inter vivos trust because it's effective during the client's lifetime. And one of the advantages is that a trustee has authority to act even if the client is living. So if the client becomes incapacitated, a successor trustee can take over management of the trust for the client's benefit. A will only controls probate property, so it's very important not just to sign the will document, but also to make sure that beneficiary designations are consistent with the plan that is, held in the last will and testament. A revocable trust only controls trust property. So once again, you can't just sign the trust. You also have to make sure you transfer assets to the trust or name the trust as beneficiary on your accounts in order for it to work as intended. A will has to go through probate and will not be effective until the judge issues those official court documents called letters testamentary or fiduciary letters. Whereas a revocable trust doesn't have to be filed with the court. It doesn't have to go through the probate process, so funds are immediately available for beneficiaries upon death. Briefly touching on special needs planning once again, it's very important if we know that we have a special needs beneficiary to plan ahead and we can preserve means-tested benefits. And we can also name a trustee who can control funds to supplement those benefits during the beneficiary's lifetime rather than just disinheriting them, which used to be the traditional approach. So of individuals who reach or will reach age 65, 70% of those are going to need some form of assistance during their lifetime. That may be a spouse providing care, it may be a child, or we may have to pay someone to provide care. Just like everything else, the cost of long-term care is only going up. So in my opinion, this is one of the most important things for someone to plan for as part of their retirement plan. Maybe we need to pay for in-home care, assisted living, memory care, or even skilled nursing care. When I started practicing, nursing home care was only about $5,000 a month. Now I'm seeing bills ranging from anywhere, between $8,000 and $12,000 a month, depending on where someone lives and what their medical needs are. As attorneys, we don't sell long-term care insurance. We certainly encourage our clients to explore those options. But many times when a client comes to us, they either haven't qualified for long-term care, maybe they can't afford it, and we have to discuss the resources available for them that perhaps we can assist with. And the two primary resources we use to help pay for long-term care include VA aid and attendance and also Medicaid. So there are some specific criteria for each of those benefits that I'm going to run through to determine whether or not someone qualifies. So first, with regards to the VA benefit, the applicant has to either be a wartime veteran or the unremarried surviving spouse of a wartime veteran. So a wartime veteran is someone who served 90 days active duty. At least one of those days had to be during a wartime period. So that includes World War II, Korea, Vietnam, or the Gulf War. And I'm sure that future wartime periods will be defined by Congress. The veteran also could not have been dishonorably discharged. So if they were discharged for any reason other than dishonorable, they will still qualify as a wartime veteran. And it's important to understand they didn't actually have to be deployed overseas as long as they were active duty. There is a health care component to qualification for the VA. The individual either has to be in a nursing home, 65 or older, or otherwise totally and permanently disabled. They also have to be spending virtually all of their income on care to get a sizable reimbursement from the VA. So most of the time when we help clients qualify for this benefit, it means they're paying for assisted living, in-home care, or even skilled nursing care. There are some other recurring monthly unreimbursed medical expenses, but they do have to be consistent on a monthly basis to be deducted from income. There's also a net worth limit. It's about $128,000. So that does not include the house, a vehicle, term life insurance, burial plots, but essentially anything else that can be converted to cash is a countable asset. One of the temptations, or one of the traps that individuals often fall victim to, is transferring assets to qualify for VA benefits. That can be a problem for a number of reasons. The most obvious one is that the VA now has a 3-year look back, meaning if you give property away and apply for the VA benefit within 3 years, they will penalize you based on how much you gave away. So the more you give away, the longer the amount of time for the penalty period, which means the VA won't pay benefits. So that can cause some serious problems. The other issue is if you give away money to qualify for VA benefits and then end up needing nursing home care, then we have to deal with the Medicaid penalty period, and they have a 5-year look back. So the Medicaid penalty period can be a big problem for people who transfer assets to qualify for VA. So we typically discourage that unless someone has the guidance of an experienced elder law attorney. The VA does look at the assets of both spouses in this as well for married couples. So moving on to Medicaid, the individual who is applying either has to be in a skilled nursing facility or meet the criteria for one of the many Medicaid waiver programs. There are some budgeted Medicaid waiver programs that offer limited in-home care assistance and sometimes even assisted living or personal care homes. And the rules for each of those programs can be complicated and they are difficult. But typically when a client needs our help with a Medicaid application, it means they need skilled nursing care. And Medicaid is different than Medicare. So Medicare is insurance. So it will pay for rehabilitation in a nursing home up to 100 days. But once the rehabilitation period has expired, or if the nursing home resident stops making improvements, Medicare no longer pays. And that means Medicare supplements no longer pay. At that time, the individual is either private pay or using Medicaid or long-term care insurance to pay for nursing home care. So who actually qualifies for Medicaid? We already covered the requirement that they have to be in a skilled nursing facility or meet the Medicaid waiver criteria. But there are income and resource limits because this is a means-tested benefit. So if someone's income is over the Medicaid income cap of $2,300 a month, they have to set up a special type of bank account called a qualified income trust account. And it's really just an extra thing to keep up with. The excess income has to be deposited into that account every single month and then paid to the nursing home. There is some flexibility for married couples. If we have a married couple and the healthy spouse has low income, they can actually keep a portion or possibly all of the institutionalized spouse's income. So typically, the healthy spouse is able to keep enough income to have about $3,000 a month to live off of, and the rest of the institutionalized spouse's income does have to pay the nursing home bill, and Medicaid picks up the difference. There's also a net worth cap for a single individual is $2,000. In South Carolina, for a married couple, it's $68,000. And in Georgia, for a married couple, it's $128,000. And the net worth cap does have some exempt assets that do not count against clients for qualification purposes. So that would include a residence, one vehicle, and then some burial policies, maybe term life insurance that doesn't have cash value. There's also some exceptions for retirement accounts. Someone could keep their retirement account like an IRA and still qualify for Medicaid. However, as a condition of doing so, they would have to annuitize the account based on their life expectancy and take monthly distributions. So here we have an example of what we call the Medicaid spend down. So let's say we have a married couple. They have $350,000 in liquid assets. And over in the right-hand column, they have some exempt assets, including their home, vehicle, some insurance. They're going to have to spend down that $350,000 to that Medicaid net worth limit before Medicaid will pay for care. They're able to keep the exempt assets during their lifetime. However, at the death of the surviving spouse, the state where they receive Medicaid benefits can place a lien on the surviving spouse's estate through a process called estate recovery. And that's where they can actually recoup whatever the Medicaid benefits were. So many times we hear about someone saying the nursing home took mom's house and stuff like that. It wasn't the nursing home, it was actually the state getting reimbursed for the Medicaid payments. So as elder law attorneys, we like to help clients avoid the Medicaid spend down because we want that money to be available to support the healthy spouse and also to make sure we keep all of our options open for the client who needs nursing home care. So if we have money protected, maybe we can pay for a private room, or maybe we can pay for a private care attendant to come in and make sure that the client is receiving the level of care they actually deserve. Secondly, we can also avoid the estate recovery process and make sure that the client's assets pass to whomever they designate upon their death, as opposed to just going to the state. Once again, there are some risks where clients are tempted to transfer assets to qualify for Medicaid. There is a 5-year look back. So if you give money away and apply for Medicaid within 5 years, you're going to get penalized based on how much you give away. The larger the transfer, the larger the penalty period. Another issue is, let's say a client gives money to their child and says, hey, I want you to put this in a savings account. Don't touch it, because if I need Medicaid within 5 years, I'm not going to qualify. Well, once they give that money to the child, the client no longer has control over what happens. So if a child spends the money or gets divorced or declares bankruptcy, it's gone. There's no way to get it back. And then if the client actually needs nursing home care within 5 years, we're in a real bind because Medicaid won't pay, and now we don't have money to pay the bill. There's also some tax consequences if you give away property like real estate, which has gained value, or stocks. So imagine mom buys a house back in the 80s for $50,000. And then when she passes away and the children inherit the house, the house is now worth $150,000. So it's gained about $100,000 over mom's lifetime. Well, because the children inherited the house upon death, they get an adjusted tax basis. So mom's tax basis of $50,000 gets adjusted to $150,000 upon her death. So if the children sell it for that amount, they will not have to pay any taxes. Instead, though, let's imagine that mom gives the house away to the children during her lifetime. And upon her death, they sell the house for $150,000. And now they're going to have a capital gains bill between $15,000 and $25,000 that could have been avoided with proper planning. So instead of outright transfers, we typically use the irrevocable trust to protect assets so that they are non-countable for Medicaid or possibly even the VA benefit. And there's some advantages that the irrevocable trust offers over outright gifting to children. One of the most important advantages is that the client can retain control of the trust. So many times our clients who want to set up an irrevocable trust, they're in their 60s or 70s. They still want to control all of their investments and have the right to sell their property and things like that. And they can. They can actually be the trustee of the trust. Any assets that are in the trust will avoid probate upon death. They will be non-countable for Medicaid and VA benefits. We can preserve the adjusted tax basis upon death. And most importantly, the trust will act as a financial shelter so that if we need to draw from trust assets to supplement whatever benefits the client needs or to pay for trips or anything like that, we still can. But we have to do it in a very specific way. So here's an example. The client is the trustee. They control everything in the trust, and no one can reach into the trust without their permission. They can still sell property, make investment decisions, no problem there. However, if the client wants to take money out of their trust and use it to pay for their own expenses, or if they want to just transfer money to themselves, they have to go through their children or grandchildren or whomever they name as their beneficiary. So let's say, we have a couple, mom and dad, they set this trust up, they put their house in there and they put $250,000 in savings. And they have named their children as the lifetime beneficiaries. So they decide they want to go on one of those Viking cruises over in Europe. It's going to cost about $20,000. They cannot pay for the cruise directly from the trust because they are not considered the lifetime beneficiary. What they can do is cut a check for $20,000 to one of the children, and then the child puts that money in his or her own bank account. So now that money belongs to the child. It was an irrevocable gift. The plan is that the child will then transfer the money back to mom and dad. They put it in their personal bank account and spend it however they want to, no restriction. There won't be any taxes due on these transfers because we're transferring an amount that is less than the $11.5 million gift and estate tax exemption for 2020. If the children or the parents are worried about their estate being over $11.5 million, then they certainly don't need this type of trust. What if, though, mom and dad transfer the money to their child? They transfer $20,000 and a week goes by, the child hasn't sent them a check. Another week goes by, they haven't heard, child's not answering their phone. They get on Facebook and they see their child boarding the Viking cruise. Well, what can they do about that? Nothing, because it was an irrevocable gift. However, mom and dad still retain a power in the trust called a limited power of appointment. And that enables them to change who the beneficiaries are upon death. So if the child or whoever the beneficiary is does not cooperate with their plan, they can take away their inheritance. So they still have some leverage, even though they do limit their access to trust money. So a final overview of the various estate planning tools in the toolbox. We talked about the last will and testament, which is really a foundational document to draft around state law. We talked about special needs planning and how important it is to plan ahead to make sure we can leave money to a special needs beneficiary without jeopardizing their benefits that may be paying for housing or medical care. We talked about using a revocable trust to avoid probate, and then the irrevocable trust to also shelter assets from being consumed by long-term care expenses. So that's all I have for today.